So, number one, pitfall number one, failing to plan. So what we're talking about in this first pitfall are for folks that have done no estate plan at all. They don't have a will in place. They don't have a revocable living trust in place. Basically, they have nothing in place because they don't believe that they have enough money, or they don't believe that they're going to die, at least not in the foreseeable future, or just like a lot of people, it's like, why put a will in place if you don't feel like you need one? So I have to say you're in really good company. I don't know exactly what the statistics are, but it's like over 50% of the population of the United States of adults don't have a will in place. That's a big number. And I think that's the same number for lawyers too, which is terrible. But keep in mind that lawyers might have a lot of hubris, and they might not be estate planning lawyers. So, nobody plans on becoming disabled or dying, at least not in the near term. So totally understandable if you don't have your own will, you don't have a trust in place, you're failing to plan. So you think that the inevitable won't happen, and I hope you're right, at least for a good long time. But what happens if you do die and you don't have a plan in place? You do not have a will, you do not have a trust, you don't have anything in place to help guide what's going to happen to your estate when you're gone. Then what happens? Well, let me give you some examples of what would happen. And what I want you to understand is you do have a plan. You just don't know what it is because, and I'm talking about the state of Washington, the state of Washington has a plan for you. And it's kind of complicated. We've done other videos on this before. It's called the laws of intestacy. I'm not going to bog ourselves down with what exactly that looks like. I just want you to be aware that it is called the laws of intestacy. What does that mean? Intestacy means you don't have a will. So let's take some real world examples of somebody that doesn't have a will, they have not planned. Let's say mom is single and she dies and she has no will. She has 3 adult children. Now, there's a lot of scenarios we can go from this. Maybe she has 3 kids and 2 of them are her favorite and one she's estranged from, and she wants to disinherit, but she never took any action during her life to disinherit that 3rd child. That child will inherit. Everybody will get 1/3, 1/3, 1/3. The state is trying to figure out what you would have wanted had you done a plan. And they're not going to go do a plan based on, well, let's disinherit somebody. If you want to disinherit somebody, you've got to do that yourself. The state won't help you with that. I do want to throw in at this point that some people think if you don't have a will and under the laws of intestacy, the state gets everything. No, they don't. The state is not trying to grab things from you when you die. The state wants to follow through with what they think you would have wanted. You have 3 kids, they each equally receive. Let's change up our scenario a little bit. Mom has 3 kids, but one of them is disabled and receives government needs-based benefits. In that situation, since mom didn't have a will, they each will inherit 1/3, 1/3, 1/3, but the child who is disabled will lose their government needs-based benefits because typically that person can only have $2,000 in countable assets. So they receive, let's say it's a relatively modest estate. It was a house, it sold for $300,000. I like easy math. So $100,000 to each of the 2 kids who are non-disabled, $100,000 to the child who is disabled. What happens? They receive that money, they lose all of their benefits that are resource tested, which is what I mean when I say needs-based benefits. So they lose their housing, they lose their income, they lose their, it goes on and on. They lose their benefits until they've either, number one, spent down all of their 100,000 inheritance, or taken some further action, like see an elder law attorney who will then say there are options that we can put into place to take your inheritance, put it in a special kind of trust, you get your benefits back. But the problem with doing this, what I'll call post-mortem planning for special needs, is that the state is going to be involved. The state likely will get any money that's left in this trust we had to create for this disabled person. So not a good plan, but probably a better plan than spending down all the money. But the best plan would have been for mom to see an estate planning and elder law attorney so that her kid would not be kicked off of benefits or have to go do a new plan, like I just explained, post-mortem with an attorney. So not having a plan means actually that you do have a plan. It's the state's plan. It's probably not the best plan for you. Rarely is it. So not having a plan means that the people who will inherit from you will have probably some adverse consequences from you failing to plan. So, I mean, that's an obvious one. You know, a pitfall number one, failing to plan. Don't put your family in that position. Make a plan.